Hello for the people that have joined. I'm Chris Davis with the Printing Industry Midwest. I think everyone that we currently have on the HR Huddle call, um, I know, but maybe we'll start with a quick introduction for the people that are here, just to say your name and what company that you're with, and we'll try to um, hope that after that, Tom Revnew from Littler Law will be on the call. But so I will start with Angie.
Just had to unmute myself there. Hi, I'm Angie Jonas. I'm with Quantum Graphics in Eden Prairie, and I enjoy this meeting a lot.
Yay. Well, that's exciting. Thank you so much. Okay, and next we'll have Sammy. I think this is her first HR huddle.
Hello, can everyone hear me?
We can.
Okay, this is my first HR huddle. I'm Sammy, the HR coordinator at John Roberts. I work with Debbie and super excited to be here.
Good. We're glad to have you. Debbie, you don't show mute. I know you might be driving. I don't know if you can introduce yourself.
Hi, I'm Debbie. I am driving, doing two things at once. Let's know. John Howard's company. That's it.
Hi, Debbie. Drive safe.
Yeah.
Amber, we have you next. Oh, she has limited technology today, no microphone. So that's Amber Owens, and she is with Right Plus Relevant Packaging down in Omaha, Nebraska. Hi, Amber. And then we have Kevin. I know he's on mute currently.
Yes, hello. This is Kevin Kapsner. I'm with Range Printing in Brainerd, Minnesota.
Hi,
And
Kevin.
been a
Thank
PI member for many years, so good to hear
you.
this information coming through.
Many years. Yes. Thank you so much, Kevin, for joining. And I believe we have Barb on the call too, right?
Yes. Hello, Barb from Streamworks, Barb Stadolka. And we've been with PIM since 2013 when Streamworks started.
That's awesome. Thank you, as always. And I do believe Tom joined the call. Now we're just introducing ourselves at this point, Tom.
All right. Hi, everyone. I'm Tom.
From Littler, and he is actually at the top of the spotlight here. He is going to give us an update on employment law. Do you have everything you need? Do you want Ben to give you share access? Are you going to show anything or just talk? Oh, you're on mute.
There we go. Is that better?
We can hear you, yes.
All right. I did put together a very short PowerPoint. I just thought it would be helpful. And I thought I had saved it to my desktop, and obviously I didn't. So I'm just trying to
Find it.
yeah, so bear with me for one moment. And yeah, if you do we have a share screen now?
Ben?
Yeah, you should be able to just start sharing.
Okay, so I'm going to pull this up and just give me a couple quick seconds here. So I believe you can see my PowerPoint, right?
We can.
All right. So Chris, thanks for having me. Chris asked me to just do a very quick 2025 legal update. So I'm going to keep this somewhat quick, just in the interest of time. What I thought would make more sense is to leave questions to the end, or you can shoot a chat and I'll try to address it at the same time. But a lot of this is going to be review and a couple reminders, and then I'll get into a little bit with the new administration. I know we have some that are joining us from outside of Minnesota, although I think the majority of folks here are from Minnesota. So the first part of my topic is really addressing some recent developments in Minnesota law. So, as Chris said, I'm a shareholder with Littler Mendelson. I've been practicing labor and employment for over 30 years. I know I've met a number of you in other settings. So, a couple things as far as today's agenda. What I'm going to touch upon, as I said, are some reminders of some things that took effect this year with regard to job postings and salary ranges. I'll talk a little bit about earned sick and safe time, independent contractors, drug testing, banning non-competes and service contracts, paid FMLA amendments, and what to expect under the new administration. So Chris gave me a half hour to talk, so I'm going to talk as fast as I can. The first is, this is again more of a reminder, but in case you forgot, effective January 1st of this year, all employers with more than 30 employees must disclose in their postings for each job opening the starting salary range, which would include both the minimum and maximum salary and hourly compensation range, and then two, a general description of all benefits or other compensation that you're offering, which would include health and retirement, but anything beyond that as well. And some of the questions that have come up over the course of the last 6 months since this law took effect is, number one, I think a lot of people are struggling with regard to what to put down for their starting salary range, particularly if you have different classifications within the same position. And what I have told clients and seminar participants is, it's a good faith effort with regard to how you're going to comply with this law. The second issue that comes up is, what does posting mean? And so a posting is very broadly defined as meaning any solicitation intended to recruit job applicants for a specific available position. So it could be Indeed, it could be recruitment done through a third party, certainly includes any postings that you're putting up within your business as well as far as job openings. But just keep in mind that you are required to provide this information from a job posting standpoint. Another question that comes up is, well, gee, what if we don't do this? What are the potential ramifications? There's not a civil cause of action yet, but there is a mechanism in which the state Department of Labor and Industry can do an investigation and issue penalties as a result of your non-compliance.
Hey,
Second-
Tom, just a quick question, just to clarify. So employers with less than 30 employees do not need to have a salary range, is that correct?
That's right. And then the other question, just to piggyback on that, Ben, is, well, gee, what happens if I'm an Iowa employer and I have 100 employees in Iowa, but I only have 1 or 2 employees in the state of Minnesota? Am I required to comply? I think that's an open issue. My position is you don't have 30 or more employees within the state, and therefore you don't have to disclose.
Okay, thank you.
Second item is changes with regard to earned, safe, and sick time. The item I wanted to focus on is with regard to changes with the earned, sick, and safe time law. Is there is a statutory provision which, if you read it, and it's on the screen, but if you read it, it's pretty ambiguous as to what the legislature was intending. Essentially says that all paid time off or other paid leave made available to an employee by an employer in excess of the minimum amount required by the act for absences from work due to personal illness or injury, but then not including short-term disability, long-term disability, or other salary continuation, must meet or exceed the minimum standards or requirements for the use of earned sick and safe time. So I can tell you, I read that intentionally because my guess is most of you, and I'd be surprised if any of you, understand exactly what that statutory language means. I certainly don't understand the language, and there's a debate amongst lawyers with regard to what that language means. The Department of Labor and Industry has issued guidance, and their position is that if you offer paid time off that is designed to comply with your requirements for earned sick and safe time, then all of that time must be allowed to be used for ESST purposes. So as an example, let's say you have employees that get 4 weeks of paid time off, and they can use that paid time off for any reason. The state of Minnesota has said that that means that you have to allow the employees to use that time in 15-minute increments for ESST reasons. You can't ask them why they're taking the ESST, right? As the law prohibits that. And then in addition, they're entitled to all the protection as a result of their use for ESST. And so I've spent a fair amount of time at the end of last year and even beginning of this year advising clients with regard to what direction do they want to take with this new amended provision that took effect January 1st. And some employers have taken the position that we're getting rid of our paid time off and we're going to have a vacation bucket, and you can only use that time off for vacation. And you're going to have a sick time bucket. You can only use that time for sick time. Where I'm seeing clients go to two buckets is where they're really concerned about abuse by employees. And so what I tell clients is it's a business by business decision with regard to how you want to address this. Some clients are taking the position that, you know what, we're going to have an ESST bucket that will essentially be a PTO bucket that employees can use ESST for all PTO reasons, but that's going to be a small bank, and the rest of the bank is for pure vacation. So it's kind of a hybrid where they're giving employees a little bit of flexibility with regard to how they use the ESST, but still complying with the ESST. And then other clients are maintaining, at least this year, no change to their PTO policy and just taking a wait to see on abuse. And like I said, I think it's a business by business decision on what you do and whether you are concerned about potential abuse or not. Another item, and I put this on this slide because I just talked to a client yesterday, and I thought it would be a good reminder. Before we had the recent amendments to the Earned Sick and Safe Time law last May, a lot of employers had drafted their PTO policies that employees don't get ESST or paid time off until they've worked 80 hours. And just keep in mind that the law was amended to clarify the legislature's intention, which employees begin to accrue earned sick and safe time and can use it as they accrue it if when you hire them, they're reasonably anticipated to work at least 80 hours in a year. Another item that I'm reminding clients of and seminar attendees because it's something that folks oftentimes overlook, which is last year, the state of Minnesota dramatically increased the penalties and potential violations when you misclassify a worker as an independent contractor when they should have been classified as an employee. And in fact, the law was amended such that owners, partners, or an officer of an agent who knowingly or repeatedly engages in the misclassification of workers can be held personally liable for that misclassification. And so, you can have a penalty of up to $10,000 per violation. And the way the state wrote this law is if you misclassify an employee who is misclassified under a local ordinance as well as state law, as well as under federal law, each misclassification under each of those laws would be a separate violation. So one employee for the type 1 violation under this statute could lead to a $30,000 fine. Then they have a separate type of violation is where you fail to report or disclose a person as an employee to any local, state, or federal agency when required. That can lead to a penalty of up to $10,000 per violation. So talk about where you're required to report your payroll to the state for unemployment purposes, for tax purposes. Every time you misclassify somebody or fail to disclose that individual can lead to a penalty up to $10,000. And so if you are a business that uses a lot of independent contractors, you're really going to want to do your due diligence to make sure that they truly meet the criteria for being an independent contractor. And then the last piece on this slide that I'll mention is, oftentimes when you work with attorneys, we'll make sure that you draft an agreement where an where an individual is agreeing that they are in fact an independent contractor and that they're filing their own tax returns. But if you prepare a document where you know that they're misclassifying or misrepresenting themselves as an independent contractor when they're not, each of those agreements would be considered a separate violation of the law. And again, a $10,000 penalty for each violation. And then, of course, those are penalties. But then for employees who are misclassified, the law was amended to make it clear that those individuals who are misclassified as independent contractors when they should have been treated as employees are entitled to compensatory damages, which means if you've misclassified them, they're entitled to any overtime that they worked, any shift differentials, any vacation or sick pay that you offer. They're also entitled to any benefits that you offer, which could include, if there are any employers on this webinar that have an ESOP, that means that those individuals would be entitled to the benefits under the ESOP. So the compensatory damages could be significantly greater than the penalties that we're talking about. And then, of course, because they hadn't identified enough penalties, they made it clear that you can also face a penalty of up to $10,000 for each person that you misclassify or treat to represent as an employee under workers' compensation or unemployment. And those are different tests that you have to review. So let's say that you're a company that typically has 20 independent contractors that are working for you. If they're misclassified and you're not reporting them for workers' comp and unemployment, you can look at that as 20 employees times 10,000, you're at a $200,000 penalty. And if you're misclassifying them under workers' comp as well as unemployment, your potential exposure can be 400,000. And then, of course, I know in the print industry world, there's often a lot of buying and selling of businesses. And I want to emphasize that if you are buying a business and you're involved in the due diligence as an HR professional, one of the things that you're going to want to look at is whether the company you're buying has any independent contractors, and if so, have they complied with their obligations? Because if they haven't, there's a very strong chance that if you buy that company and they misclassified workers as independent contractors when they are employees, that you would be subject to their liability through successorship liability. Because as you look at this slide, establishing a successorship under the independent contractor law is pretty easy, right? If you buy a business, one factor that the state would look at is, have you continue to have one or more of the same managers of the business? Well, you probably do, right? But two, are they performing similar work in Minnesota? Well, they probably are, right? And then you look at the next 5 factors, and you can see that it's pretty easy to meet the next 5 factors. So I think frankly, I think it's going to be very difficult for you as an employer to say you're not a successor and therefore not responsible for the predecessor's mistakes in misclassifying workers. And the last thing I'll talk about with regard to independent contractor is for all industries except construction, and I won't get into construction. The state focuses on 5 different factors to determine whether somebody is an employee or an independent contractor. And the primary factor that they look at is the degree of control one party has to exert over the other. That's essentially become the primary factor. But then when you look at, whether an individual is considered an independent contractor for workers' comp purposes, the state looks at 34 different tests based upon the industry. So I could spend hours and hours on this topic, but obviously, in the interest of time, I'm just trying to highlight some of the more important things you need to be aware of. Just a reminder with regard to drug testing, that the law did change and took effect August 1st, which essentially says that in Minnesota, you can now use oral fluid testing to, do an oral swab, and you can do that with an employee or a job applicant. And, that's been a significant issue for employers in the hiring process where employers want to start an employee right away. But they can't because they have to go through a conditional offer, post-offer drug test. And so they wait, for the drug test results to come back. And this is a reminder that in Minnesota, as of August 1st, you can do the oral swab and you can do that for job applicants. And so that may get applicants to work a lot faster. And if they do test positive, you still have to comply with the requirements under the Minnesota Drug and Alcohol Testing Statute, which essentially says that the employee has a right to go to a drug and alcohol test laboratory at no cost within 48 hours. And keep in mind that in Minnesota, from a drug testing statute, you have to have a specific language built into your drug testing policy. And you still have notice requirements with regard to if an employee or applicant tests positive. They have a right to get a notice of their positive test result. If it's a first positive test, they still have, before you terminate them, you have to offer them rehabilitation before terminating. And if they agree to rehabilitation, you can't terminate. But bottom line is, you can now use the quickie test, the oral fluid test, if you so desire, for both applicants and employees. If you do decide to use the oral testing, you're going to need to update your drug testing policies and incorporate that language into your policies. Another reminder, in Minnesota, non-competes and service agreements are now void. So effective July 1st of last year, you cannot have in your contracts where you restrict or restrain or prohibit a customer from directly or indirectly soliciting or hiring your employees. And if you have an existing contract that violates this provision, that contract is null and void. And you can see service provider is very broadly defined. So bottom line is you can't have an agreement with your customers that they won't hire your employees or solicit your employees. So next item is paid FMLA. The bottom line is, just a reminder, it's taking effect January 1st of 26. The Department of Labor and Industry has been working hard on the proposed rules to help guide employers with regard to what they need to do and what they can do with regard to either self-insuring or buying a product in the market that essentially meets the requirements of paid FMLA versus going through the state program. I think we're close to getting those rules, but more importantly, I suspect you're going to see a lot of educational opportunities in the next few months, certainly within the next 3 months, because employers need to start preparing to become compliant with the paid FMLA in Minnesota. So that's all I wanted to touch base with on there. And then the last topic, what to expect under the new administration. And of course, we're 3 days into the new administration. Obviously, we have a new president, new vice president. And of course, we have the Republicans holding the majority in both the Senate as well as in the House from a federal level. I think these numbers have changed a little bit in the last few days, but regardless, the Republicans still maintain majority in both the House and the Senate. So I suspect you're going to see some laws that get pushed through that we wouldn't see if we had a divided Congress. So as you know, there's a lot of pending litigation with the Department of Labor. First, as you know, we had the overtime threshold for salary exempt employees was going to take effect January 1st. A federal court vacated that rule, set it aside. The DOL had appealed that rule. We now have a new administration. And the question is, what is the new administration going to do with the overtime threshold for salaried exempt employees? Are they going to continue to fight and seek to get the lower court's decision vacated? That's an open question, and typically you would say that they're going to withdraw their appeal. Having said that, as many of you know, President Trump nominated a congresswoman out of Oregon who is very friendly to labor. And so she very well may keep pushing the overtime threshold for salaried exempt employees. We'll see. And then, of course, we had an independent contractor rule that was issued by the Department of Labor, and that rule was challenged. And again, what is the new labor secretary going to do? Who knows? OSHA issued a walk-around rule that essentially allowed a third party to show up at a job site or at a business where there was an investigation or an OSHA inspection going on, and that third party could participate in the OSHA inspection if the inspector believed it was in the best interest. And of course, this rule was passed to allow unions to come on site for organizing purposes. That rule is being challenged, and the question is, because it's being challenged, will it be rescinded under the new administration? And then, of course, we heard a lot about the FTC non-compete rule, which was prohibiting non-competes in a very broad sense. That rule was enjoined. The FTC appealed that rule. And of course, with the new administration, I do suspect that that rule will essentially be rescinded and we won't have to worry about the FTC non-compete. But as you can see, with the new administration, there's still a few open items with regard to what does the Trump administration do with pending challenges to some of Biden's labor rules. With regard to federal agencies, uh, on his first day of office, President Trump named Marv Kaplan as the chair of the National Labor Relations Board. You may be aware that the former chair, Lauren McFerrin's term, was not renewed by Congress. So right now, the NLRB is made up of 2 Democrats and 1 Republican. The Democrats that have sat on the board have been very aggressive with regard to employee rights. Many of you have heard some of the things that the Biden board has done with regard to changes in interpretation of the National Labor Relations Act. I suspect that we will have a Republican board, but I don't think it's going to happen immediately. And so I think we're still going to see some decisions that come out that are going to be employee friendly. But you know, if you had asked us back in December what was going to happen, most management side labor lawyers believed that the general counsel, Jennifer Abruzzo, was going to be terminated on day 1. That hasn't happened. Abruzzo is still around. She is essentially the head of enforcement before the National Labor Relations Board, and she's the one that has really changed the direction of the NLRB to being very aggressive to protecting employee rights to the detriment of employer rights. So I still think Jennifer Abruzzo will be terminated, but when it's going to happen, who knows? We have ongoing constitutional challenges as to whether the NLRB is in fact constitutional. I think those will continue. There are a lot of pending challenges against state laws where states have issued laws like Minnesota banning employers from having captive audience speeches, in addition to the NLRB recently banning captive audience speeches by employers. We're going to have a lot of decisions that are going to come down in the next year with regard to whether states can issue these laws. And of course, I suspect we might get a decision dealing with the federal law or the federal NLRB decision that banned captive audience speeches. As many of you recall, in separation agreements, the Biden board prohibited confidentiality provisions and non-disparagement clauses in separation agreements. I think that's going to be reversed at some point. Many of you know that the Biden board had been attacking language on employee handbooks. I think that the war on handbooks is probably going to end in the near future as well. So with going back to the U.S. Department of Labor, I think ultimately, the salaried exempt overtime rule, I think ultimately that's going to be repealed. I think the independent contractor rule ultimately is going to be repealed, but we'll see what happens. I think the walk-around rule will likely be withdrawn in the near future. There were proposed rules on heat standards and protecting employees who are working outside from heat. I think those proposed rules will probably be vacated as well. The EEOC, as of this last Monday or Tuesday, Charlotte Burrows, who had been the chair of the EEOC, lost her chairship, and that is now with Andrea Lucas. And so Andrea Lucas is now the chair. She's a Republican. So you'll see changes with regard to the EEOC. And I think perhaps the biggest thing that we're probably going to see is the EEOC's efforts on DEI probably will go away. Some believe that the EEOC may focus on claims of reverse discrimination. We'll see. And then with regard to your EEO1 and employee compensation data collection, we think that's going to go away as well. Some think that there's going to be changes with regard to the LGBT protections and how the EEOC has been interpreting them. And some think that there's going to be an emphasis on religious liberty in the workplace. We'll see what happens. I already talked about the FTC with regard to the non-competes. I think they're going to abandon their appeal, and I don't think the FTC will be likely involved in labor and employment related issues. And then immigration. Immigration, obviously, we have a new border czar, Tom Homan, and really what I want to focus on is I-9 compliance and enforcement. If I were an employer, I would be focused on, are we compliant with our I-9s? We saw a dramatic increase in I-9 audits through ICE when Trump was in office the first time. I think we're going to see an increase in audits taking place again. You can see that, you know, in 2019, under the Trump administration, they did about 6,500 I-9 audits across the country. And then fiscal year 2020, they were looking at doing 15,000 I-9 audits, but then we were hit with COVID. So I suspect you're going to see an increase in I-9 audits, which just means, you know, now's the time for you to do your internal self-audits to ensure that you are complying with your obligations for purposes of the I-9. And of course, I think if you rely on legal immigrants to perform some of your work, I think it's probably going to be more difficult for some of those immigrants to get the required visas. And of course, the cost is going to increase as well. So that's a lot of information in a short period of time. I think I went over my time a little bit, but I thought that would be helpful for you guys just to kind of have a sense of where we're at and just a reminder of some things that took effect as of January 1st. So I'll stop talking, and if there are questions, I'll certainly take them. I'll stop sharing my screen as well.
Thank you, Tom. That was a lot of information to take in. Are there any questions before we move on? Tom is a member of the Printing Industry Midwest, and also sits on the PIM board of directors. He is someone that I will always ask questions of, and I also have referred, I think, several of you to him. His contact information, if you don't have it, I highly recommend you earmarking that for questions. He's good to send an email to, phone calls, etc. He'll answer some questions. So anyway, we thank you for all of that valuable information. Oftentimes it does get lost in all of that you do as HR professionals. So he's a handy tool to have at your disposal. But I don't see any questions at this point, Tom. This is recorded, so we will be sharing it with all of our HR professionals and people that have attended in the past for the HR Huddle too. Thank you.
Thank you.
So then we're just going to move on to a few things that I just want you as HR professionals to be aware of for the printing industry Midwest. You know, this association is not just for the PIM contact, it's for everyone in your organization to have access to these benefits. So I wanted to talk about number one, right after employment law update is peer groups. And ways to be involved with PIM other than just, you know, taking or having access to our PIM publications, making sure you're deep diving into our website all the time, because we do have things that we offer. I'm going to talk about peer groups. We have the Financial Executive Council. They are a group that how we do it is we earmark it in our, we have affiliation codes in our database. And so if you have anyone in your company that is responsible for accounting, financial sort of functions in their job, we highly recommend them to be a part of the Financial Exec Council. They have webinars every other month, generally falls on the third Wednesday, correct, Ben, but sometimes not.
Yes.
But we do put notifications for the Financial Exec Council well before each topic that is going to be covered. And we put that in on our events section. We put it in our eLoop emails as reminders, and we send standalone emails. And that's a good recommendation for not only, I know some of you even wear that hat in the smaller companies, but make sure that you're getting the notifications of being a part of the Financial Exec Council. Ben Dolly, who is on this phone call or on this Zoom, manages that council. And are there any questions about the financial execs? Okay, so another peer group is the young professionals. And this is strictly pretty social in nature. We do have our upcoming event on March 13th at the Top Golf in Brooklyn Center. This has proven to be a very fun event for young professionals. Is considered anyone from age 22 to 45 is the range. And we also do recommend that if you are beyond those ages, that maybe if you want to come and network with the young professionals, we're not going to turn you away. It's also, we do tend to meet 3 other times in the year. The other time is we try to do a happy hour in May, a game at the Saints, St. Paul Saints and St. Paul in September, and then we co-combine the Mingle Jingle in December. How do you get involved in the young professionals? Same thing. Just let us know whoever you want to be a part of the young professionals, and we'll add that affiliation code in our database so that they're getting our communications about the young professionals. Down the line, we're going to try to make it a little more meaty and do other things besides networking, but that's working pretty well for right now. We think, you know, the young professionals at all of your companies do like to see other young professionals working in print, so it's a good way to connect and network. The HR Huddle, we just brought back into the fold. So that is considered another peer group that we have. And we are starting to work and get you all together to kind of go over topics and talk about things that are helpful in making your job easier. There's 2 other places currently that you can volunteer. We have our PIM board of directors, as well as our PIM Education Foundation. Right now, currently, our board of directors is almost going to finish. We operate on a fiscal year, so terms, if they will be ending March 31st. Board terms are, remind me, Ben, they're 3-year terms, right? And you can, it's 3 years.
For the PIM board, yes.
Yeah, 3 years, and you can re-up, I think, up to 3 terms is
Yeah.
what I'm off the top of my head. But if you're ever interested in getting involved in that group, the other one, like I was talking, or is the PIM Education Foundation. We have, I think you've seen that we do offer scholarships to career seekers, and we have a foundation board. And so that is another way that you can volunteer through PIM, is sitting on that board. And those are 2-year terms, and I think you can serve up to 4, maybe longer. We hold on to the foundation people as much as we can, but these are 2 other ways to get involved in the association if you're ever interested in pursuing opportunities in those leadership positions, or if you know of someone at your company that you think you would like to see serving on the board or the foundation, you could let them know to reach out to me to say, hey, I would like to do that. So just so you know, that information is on our website, as well as all of these opportunities are ways to get deeper into the printing industry Midwest. And we always encourage you to let your employees know about it, because this is a membership that everyone can take advantage of in your workplace. And that's a great thing to use as a marketing material, marketing when you're hiring and being a part of. Are there any questions on peer groups? Okay, well, I just want to make sure that you guys know that they're there. They're on our website. And if you ever have questions, you can reach out to Ben or myself, and we will give you more details on those different peer groups. Next, on the agenda is talking a little bit more about the Star Awards and the People of the Year. We talked about this at the last HR Huddle, but deadlines are fast approaching. So we want to make sure that you're telling your key personnel, are you getting your stuff turned in? If you are participating in the award entries for projects to be judged, those need to be turned in by next Wednesday, January 29th. The steps on how to submit printed pieces are right here on our website. Ben is pointing them out with his little arrow and scrolling down to let you know how to do that. You can access all the information on how to submit those pieces online at our website. Also, People of the Year, they are also due on January 29th. I've talked about this a bit. If you guys don't have an employee recognition program, using this as your employee recognition program is a great place to start. You can nominate in multi-categories people that you think would be deserving. Everyone that you nominate is recognized at our Star Awards banquet. One person does win, but like I said, everyone is recognized. So if you nominate a person from your company, you're considering that person the best of the best at your company. That's a great honor for that person to receive. And then to get that additional recognition amongst their peers is also pretty awesome. So if you have questions about the nominating coworkers, it is at the website along at the Star Awards with the call for entries. And so rapid date approaching. Recognition for the Star Awards, if you want to mark it down on your calendar, is June 12th. It will be at the JW Marriott Mall of America. Again, a super fun event. We'll give you more details on that probably in April. or May, when is our next, and gosh, then we'll be almost just a month away from the Star Awards the next time we meet. Another benefit, does anybody have questions on the Star Awards at all? If you don't, I will move on to another buying program that maybe not all of you are familiar with, but this is something that is a group benefit for you as an employer, and you get discounts by being a member of PIM. We have what is called the Printers Disability Trust, and it is on our website. They have group life. They have disability, dental, vision insurance that you can pass along to your employees. These are all falling under an umbrella. Like I've said in the past, we work with other print associations as a big group, and that's how we have access to this program called Printers Disability Trust. And so if you're ever looking for some of these benefits to have for your employees, all you have to do is go to this part of our website. There's contact information of next steps of how to get access to that information. Are there any questions on the Printers Disability Trust? Okay, and then Ben showed you this is the group buying discounts page. And so if you guys are finding time where you want to look to see how you can save money, what are some of the benefits, go visit this page. All right. I think Ben is going to just briefly touch upon the wage and benefit survey. He manages that for PIM.
Yeah, just letting you know that if you participated in the survey last, I want to say June, July, you should have received the results for free in October. And if you did not, just let me know and I'll get them for you. Or if you did not participate as a PIM member, you can purchase the results for $250. And there's a lot of great information in there. It's well worth the price. So yeah, just let me
Yeah.
know if you want it.
And if you didn't participate this year, highly recommend starting to do that in when they come out again for call for participating in June, because the information that you have access to is improving each year, and they got some great tools in there for you to have access to for all the year round. Another thing I wanted to touch upon briefly, and I I think I may have sent the link to you, but I'm not sure. I don't know if any of you or all of you are familiar with Workforce Wednesdays. They're through the Minnesota Employment Economic and Development Department. They do a webinar. Usually, I think it's the first Wednesday of the month. I don't know if you've signed up for these before. I do try to participate in them, but we have had a couple of our members ask about employee resource groups in today's workplace. And so this is a, a topic that the department is covering in February, talking about employee resource groups. For those of you that might have attended the Women in Print this year, our speaker, Becky Oakes from Taylor, talked about they have a woman's employee resource group at Taylor that is quite phenomenal. And so if you're interested in, in learning more of how you should set these up and what sort of guidelines you should have, I highly recommend you sign up for this Workforce Wednesday. And then you'll get notifications, or if you want to, you can also get signed up for notifications to find out what the topics are, because they do this every first Wednesday of the month, and they're really kind of nice topics to listen to. And I think even if you're outside the state, some of these topics are kind of interesting to listen to as well. And maybe check, or I will see what is going on in the other states as well to share that information. But the Department of, the Department of Employer and Economic Development and the Department of Labor and Industry for Minnesota, Iowa, Nebraska, South Dakota. I always tell our HR people that these are good website placement bookmarks to always go see what's going on there, see what sort of programs that they have. That's always important to do. I will send the link to this in the notes or that the recap that I send for you. And lastly, I know Ben has already been to the PIM events calendar, but we just want to reinforce that the PIM events calendar has what is going on, and the current thing is deadlines are coming up for the Star Wars, and then on March 25th, we have or March 25th. March 13th, we have the Young Professionals event coming up at Top Golf in Brooklyn Park. And also, if you see in April, which is going to be, I'm sorry, that is when the next HR huddle will be, is the same day as the Pin Seekers in Tiffin, Iowa, which is a networking event down there at something similar to Top Golf. And so the next HR event we are targeting to have HR Huddle is on April 25th or 4th. I'm sorry, April 24th at 11:30. And this one would be an in-person as well as offered remote, so we could have a little bit more networking going on. I'll have to talk to Ben about that because I might be in Iowa. He might be the person in person here, but we'll talk about that. But currently, that is scheduled for the next HR huddle is the 24th of April, if you want to mark that on your calendar. I think that puts us to the end unless there's any other questions that you want to throw out there, comments, things you would like to see. You can let us know now, or you can always let us know via email. I have been testing out the HR Huddle listserv a couple times, passing you guys through there. So just so you know, I'll try to put that in the notes again. But if you ever have questions where you want to talk to other PIM HR professionals, that HR listserv is working. So you can post questions there and see if I'm not going to say you're always going to get an answer, but sometimes there's good chatter that can happen on a listserv. I also can put questions out there. If you're not comfortable, you can email me and I will put the question out for you if you'd like to. So that's pretty much all we have for today, unless you are interested in talking about anything else. If not, I will say stay warm, and it's nice and sunny out today, I can see. So at least the sun's out, and we'll see you in April, if not before. We're always here if you have questions. Thank you so much. You have a good day. Bye.